The moderator of today's panel is a judge on the United States District Court for the Eastern District of Pennsylvania, and it's a privilege to be able to introduce him because he hosted the first Federalist Society event I attended when I was a law clerk on the Third Circuit, and he was the head of the Philadelphia chapter of the Federalist Society. But Judge Wolson, prior to being on the bench, was a law clerk for a judge on the United States District Court for the Eastern District of Pennsylvania. He then spent a huge part of his career at Covington and Burling, which is where I went after my clerkship, and the judge was a huge mentor in me going through that whole process. But then was a partner at Dilworth Paxson in Philadelphia, where he was on the management committee, and I think ran the plaintiff rights committee. But Judge Wolson was the former head of the Philadelphia chapter of the Federalist Society. Every year he participates in the program and is usually highly rated in terms of his humor and leading the different panels that he runs on. But it's an honor to have him again, and I'm going to turn it over to Judge Wolson to introduce the two professors who are going to be debating. Thank you.
All right. Well, thanks, Steve. I'm thrilled to be here, thrilled to be back. I'm particularly thrilled that you decided that the powers that be decided to move the conference even closer to the courthouse. I think it was a great decision, not just for the view. I get used to the view, but you all don't, so it's pretty special. I was really happy when Steve Lee reached out to me and asked me to moderate a panel here. I'm always thrilled to get to come back. I was excited when he told me the topic. I thought, well, that'll be interesting. And then I was excited when I saw that the Supreme Court decided they were going to hear argument on this topic, because I thought that would make it that much more exciting for everyone who was involved. And then I found out that Steve had scheduled me to moderate the panel that's right between all of you and the bar, and I was a little less happy about it. But I'm hoping that we can hold your attention here. We have a really interesting topic and two really interesting panelists who are going to present for you. I'm going to do very brief introductions. I know you all carry little computers in your pocket and can look these folks up if you want to in more detail. To my left and your right is Professor Ilan Wurman. Professor Wurman is at the University of Minnesota School of Law, where he teaches administrative and constitutional law. He has written in a whole host of prestigious journals that I assume each and every one of you keeps bedside. He recently published an article in the New York Times about our topic today, Birthright Citizenship, and is the author of a longer form article that I'm sure we'll be getting into as we talk today on the topic as well. He has an undergraduate degree from Claremont McKenna and a law degree from Stanford. To my right and your left is Professor Evan Bernick of Northern Illinois University, where he teaches constitutional law, administrative law, criminal and criminal procedure, and legislation. In 2021, he co-authored a book with Randy Barnett on the original meaning of the 14th Amendment. He has both undergraduate and law degrees from the University of Chicago, and he too has published in a range of journals that are both really interesting and, at the right time, great cures for insomnia. And so I'm thrilled to have both of them here with us today. They seated me in the middle because I may have to play a little bit of Mills Lane as we go, and so I'll do the nose tap now. And let's get started. I want to just frame this very quickly for everyone who has not gone back and brushed up on the specifics of the text of the 14th Amendment, which gives rise to the debate today. And what we're talking about is Section 1 of the 14th Amendment, really the first sentence, which says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So I want to start and ask Evan to weigh in first, because I think the position he's going to take is consistent with a view that has been sort of the conventional wisdom for a long time, which is that if you're in the United States and you're born here, with very minor exceptions, you are a citizen of the United States. And I guess, Evan, I'll sort of put it to you to explain that and maybe explain to us why that's not just conventional wisdom as an example of collective groupthink, but why it's really sort of supported by the structure and history of the 14th Amendment.
Well, Judge, I actually think that you put it quite well, and I'm going to just rest on the briefs at this point.
Outstanding.
I've got nothing else to say.
All right, anybody want to go to the bar? Yeah.
But seriously, I was not informed that you were known for your sense of humor, so I feel kind of intimidated opening with a joke, but I'm going to do it anyway. So I have done my best to advertise this debate, and I've made a promise to anybody who's interested in watching. Well, I made two promises. The first promise is that I would win, and the second promise is that it would be entertaining. And that does put me in a somewhat uncomfortable position because my view of birthright citizenship isn't particularly entertaining. It's not novel. It's not sexy. I don't think it's sexy. It's the conventional wisdom. It's pretty simple. And I've debated Ilan a number of times, and neither of us has ever defended the conventional wisdom that I can think of. I mean, we're originalists after all. Like, if you're an originalist, you don't often defend the conventional wisdom because the conventional wisdom is often non-originalist, or it's not been tested by originalist methods. So, like, what am I doing here in the city of brotherly love? And why am I defending the conventional wisdom? And why have I been so unbrotherly towards Ilan for challenging it? Now, full disclosure, Ilan and I have never been friends, but I suspect that after this is over, we just might be enemies. Or we won't be in amity anyway. So why? Because the conventional wisdom about birthright citizenship is correct, and in my view, obviously so as a matter of original public meaning. This isn't a house built on sand. It's a rock-solid account of the Reconstruction Constitution. There is a cross-ideological, cross-methodological, cross-branch consensus spanning more than a century in favor of birthright citizenship for the subjects of President Trump's executive order for a good reason. The leading articles supporting birthright citizenship for the subjects of the EO are state-of-the-art public meaning originalism. And when you're up against that, I think you've got a very heavy burden to carry, and I've been harsh on Ilan because I don't think he's gotten anywhere close to carrying it. Now, the conventional wisdom is pretty easy to explain. Judge Wolson is just taking you through the text. The crucial question is whether a child born in the United States is subject to American jurisdiction. And the conventional wisdom is that if you're born in and governed by the United States, you're a citizen. Jurisdiction wasn't a technical or obscure term. You can check contemporary dictionaries, we can hang out afterwards, we can go over the congressional globe together, but you can check statements that Republicans made on the ratification campaign trail. It was very straightforward. It meant sovereign governance power, experienced day in, day out. If you, in a day in, day out basis, are generally obliged to follow and are answerable to U.S. lawmaking, enforcement, and adjudicatory authority, you are subject to U.S. jurisdiction. If your exposure to U.S. governance is tightly limited and exceptional, then not. Now, there are very few classes of people who are born in the United States who aren't obligated to follow United States law. Very few people who ordinarily don't have to follow state and federal statutes, who can't be arrested, who can't be sued or prosecuted if they don't. And guess what? That's what the framers of the 14th Amendment said. That's what newspapers reported that they said. 3 categories of exceptions to subjection to jurisdiction came up again and again. Now, Ilan's going to tell you they're not, well, he might. He might tell you that they're not exhaustive, but they're representative. The children of diplomats, the children of occupying armies, and the children of members of native nations, as the Constitution recognizes them, Indian tribes, tribal citizens. Now, all of these groups certainly were exposed to U.S. law for various purposes. Like it's a federal crime to punch a diplomat. But this exposure was exceptional. And in the case of children of diplomats and tribal citizens, it was mediated by legal structures that recognized that another sovereignty was doing most of the governance of these people and limited its own power claims accordingly. And the framers of the 14th Amendment said again and again they weren't innovating. They were declaring existing law. If anything, they were getting rid of an innovation that began in antebellum slave states and was eventually embraced by the Supreme Court in Dred Scott. And that innovation was citizenship that required reciprocal consent by the individual would-be citizen and by the state. And if a state systematically denied people their civil rights, when obviously they didn't consent to their citizenship. And obviously, enslaving states loved this because it meant they could deny citizenship not only to enslaved people, but to free black people. When the court in Dred Scott said that black Americans could never be citizens, it was adopting this understanding of reciprocal consent. It surveyed the antebellum period back to the founding, found that black people had been systematically denied their rights, so obviously we, the white people, hadn't consented to their citizenship. Now, the Citizenship Clause gets rid of all that. It says if you're born here and the US governs you, you're a citizen. Just like that, Dred Scott, all that antebellum consent stuff that had no roots in the common law, stretching back to Calvin's case, or if you really want to get into it, Shirley's case and Norfolk's case, that's gone. That's what Republicans thought the law was. The Citizenship Clause codifies it, removes any doubt about it. You have to go decades after ratification to find people who are clearly raising doubts about whether the children of foreign nationals are citizens. And when they do it, they often do it because they don't like the common law that abolitionists and Reconstruction Republicans did like. That's certainly what you see from the arguments from the United States and the dissenters in Wong Kim Ark. They just don't like the idea that just because you're born in a nation's territory and governed by its laws, you're a citizen. They want the US to be like other modern nations. They appeal to international law. One of the lead authors of the Brief of the United States, the Council of Record, was a leading international lawyer. But birthright citizenship was the law of the United States, and that's how abolitionists and Republicans understood it. That's how they understood Kent and Blackstone and Cook and Binney and Rawle and Bates, and they liked it. They liked it. Abolitionists liked it because it meant that enslaved parents who traveled across state lines and gave birth in free states didn't pass on their enslaved status to their children. Republicans liked it because it meant the end of Dred Scott, full stop. In fact, they liked it so much that they embraced unambiguously the citizenship of children of foreign nationals when pressed by their colleagues in very bigoted terms about whether the children of Chinese nationals or the Roma people, whom they referred to as gypsies, would be citizens. If you're born in a state, and that state is going to demand your allegiance to its laws, of course you're entitled to the protection of citizenship. Governance without protection is domination. You're subject to arbitrary power, power you can't effectively control because that power says you have no legal rights worth respecting. Domination is unrepublican. That's the basic premise of the Reconstruction Constitution, and its drafters deliberately wrote in general terms to provide, as House Speaker Schuyler Colfax said during the ratification process, quote, that every person, every man, every woman, every child born under our flag or nationalized under our laws shall have a birthright in this land of ours. So briefly on the exceptions. Why don't the children of diplomats get birthright citizenship? Because the US doesn't claim the right to govern them without their consent, and so it can't dominate them. Why don't the children of hostile occupying armies get birthright citizenship? Well, because the US can't govern them. That's why they're occupying. That's the problem. Why didn't the citizens of native nations get birthright citizenship? Well, because the Constitution recognizes them as sovereign nations, and in 1868, Republicans acknowledged that, saying we don't govern them. We have treaties with them. They govern themselves. Now, could they dominate them? Some of them wanted to, but others said, no, we don't have the right to do that. Or in the case of the children of members of tribes whose sovereignty was not recognized by treaties or anything else, they just couldn't be subjected to US power. You couldn't bind them with statutes, sue them, anything. That's what Republicans said. Now, there is no evidence whatsoever that anyone in 1868 understood the children of foreign nationals to be excluded from birthright citizenship. And any new exception for their children would look entirely unlike the original exceptions. The subjects of the EO are not diplomats, they're not occupying armies. Their relationship with the United States in no way resembles the power relationships between the US and tribal citizens that existed in 1868 or for that matter today. There's no territory that they govern collectively. They have no governance institutions. We have no treaties with them. And the subjects of the EO are subjected daily to the unmediated legislative, executive, and judicial power of the United States. This exception would encompass millions of people who in no way resemble those accepted from US governance in 1868. So to borrow a Second Amendment analogy, it's like finding an exception to the right to bear arms that encompasses all handguns or requires you to get permission to carry a gun outside the home. That's not what the court did in Heller or Bruin. Might be a good idea, but I submit it is not any recognizable form of originalism. Debated Ilan many times about the 14th Amendment, about hard questions, questions about which thousands of pages have been written by scholars trying to figure out just what is and what isn't a privilege or immunity of citizenship. And
I'm still right about that one.
Of course you are. Of course you are. You'll get your turn. Even when I think he's wrong, and I often do, I've understood where he's coming from. I've been able to see why he reads evidence as he does. There's always somebody, some guy, Wolson, Bingham, who clearly says something that supports his position. So I've respected his methods, even if I've rejected the results. This feels different to me, and I know that's reflected in the tone of what I've resisted even calling a debate. Honestly, I've told him this is not news. I don't see why Ilan thinks this is hard. I don't think the conventional wisdom struggles to explain anything. It can deal with every exception that mattered in 1868. It's borne out through every evidentiary source that originalists are supposed to credit. Read them for yourself. Read his paper. Read the sources that he's relying on, because it's all there. It's very clear. And I think that if you're really committed to original meaning, even if it tells you things you don't want to hear, you'll hear it too.
Okay, Evan, thank you. All right. All right, so I think we got a hint that Ilan thinks otherwise. So Ilan, tell us why the conventional wisdom's wrong and why you think. I think what you're going to tell us is that the text and structure of the 14th Amendment says otherwise.
Great. Well, thank you for inviting me to discuss this controversial topic. And thank you to Evan for coming out of his normal comfort zone, which is blue sky, and coming into my comfort zone, which is a Federalist Society event. Also, the faculty lounge is not much different than blue sky. I was not making a general blue sky dig there.
NIU does not have a faculty lounge, for the record, but go ahead.
Okay, well, back to business then. The 14th Amendment grants citizenship to all persons born in the United States and subject to the jurisdiction thereof. The question is whether this phrase extends birthright citizenship to children of unlawfully present aliens or temporary visitors. Let's clear some underbrush. The Supreme Court has never decided either issue. In 1898, the court in Wurman held that a child born here of domiciled permanent resident aliens was a birthright citizen, a decision I believe was correct. But that does not resolve the present questions. As for temporary sojourners, a single state judge, prominent one, ruled in 1844 that birthright citizenship applied to their children, but two appellate judges in the same state, New York, later strongly suggested otherwise. Many think the matter is settled, but it is plainly not. The answer lies in the meaning and operation of the 14th Amendment's words. My friend and colleague has one theory as to that meaning. He argues that one is subject to U.S. jurisdiction if subject to U.S. power, if U.S. has the power to enforce its laws over the person in question. I propose that subject to the jurisdiction meant something else, although it was related. It meant subject to the complete municipal jurisdiction, both legislative and judicial, of the United States. If an alien physically present on American soil was subject instead to the law of nations, that alien was not subject to the municipal jurisdiction of the United States. And if a rule of international law provided an exception for a sovereign's exercise of a complete legislative or judicial jurisdiction over foreigners within its territory, then those foreigners were also not subject to the jurisdiction of the United States in the relevant sense. As an initial matter, this international law theory explains why the United States does not have power, as Evan might say, over ambassadors. It's not that the US cannot physically and actually exercise power over ambassadors. Of course it can. As Chief Justice Marshall explained, the ambassador's immunity, quote, is granted by the governing power of the nation to which the minister is deputed and depends on that nation's consent. The point is that exercising such a power over them would be illegitimate under prevailing rules of international law. So we have to look to international law to explain that exception. The international law framework also explains why invading armies and enemy spies were not subject to the jurisdiction in the relevant sense. Not that the United States couldn't have enforced its domestic laws against them if it had wanted to, or couldn't have exercised a full power over them. It's that under the law of nations, the laws of war governed instead, not the municipal law or the municipal jurisdiction. International law also explains why the principal drafters and advocates of the Citizenship Clause thought Native Americans were not subject to U.S. jurisdiction, even though they were within U.S. territory, many thought so, and to a large degree subject to its criminal laws, like the General Crimes Act of 1817. A rule of international law provided that dependent nations continue to govern the municipal rights and relations of their own members. Hence, tribal laws apply to disputes between tribal members. The United States did not exercise a complete municipal jurisdiction over the tribes under international law. Here's how Jacob Howard, the author of the Citizenship Clause, explained it. The phrase subject to the jurisdiction implies a full and complete jurisdiction, a jurisdiction that is coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department, that is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States now. Native Americans, he went on to say, although born within the limits of the United States, are not subject to this full and complete jurisdiction. The United States courts have no power, for example, he said, to punish an Indian who is connected with a tribe for a crime committed by him upon another member of the same tribe. So again, it's not that the United States could not have exercised a full and complete jurisdiction if it had wanted to. It's simply that doing so would not have been legitimate under prevailing rules of international law. So far, Evan and I might actually be in agreement. He accepts that the three exceptions, ambassadors, armies, native tribes, were in fact exceptions to birthright citizenship. But once we zoom out to the reason why the US could not or did not have to exercise its municipal power over these groups, whether that reason applies to other categories depends on that precise reason or explanation under international law. One might explain it on grounds of territoriality, which I think Evan did at some point. Perhaps the Native American tribes actually had their own territory. The problem with this theory is that most participants in the debate did not believe that. They thought that the native tribes were within the United States territorial jurisdiction. Of course, ambassadors and foreign armies are within US territory, but not subject to the jurisdiction in the relevant sense. So that doesn't really work. But perhaps it has something to do with sovereignty. Ambassadors and armies are representatives of their sovereigns, that's true. Tribal members are not representatives in that sense, but their municipal relations are governed by sovereignty, a sovereignty other than the United States. That's a perfectly plausible theory, and I think it's the conventional one. But what if sovereignty was only one reason under international law that a country might not exercise a complete municipal jurisdiction over certain foreigners within its territory? What if it turns out there were other international law rules to similar effect that would also capture additional historical evidence? Let me give you an example. Temporary sojourners. Under the conventional theory, children born here of temporary visitors are citizens because no sovereignty-related exception would apply. But what if I told you that the chair of the Senate Judiciary Committee, Lyman Trumbull, the principal author of the Citizenship Clause of the Civil Rights Act, wrote to President Andrew Johnson that the act would make citizens of children born to aliens domiciled in the United States? James Wolson, the chair of the House Judiciary Committee, when introducing that same language, said the children of ambassadors and of temporary sojourners were excluded. John Bingham, the principal author of the rest of Section 1, stated in 1859 his understanding of the common law that all free persons born and domiciled within the United States were citizens. The domiciliary of the child, of course, under both American and international law, followed that of the parent. William Fessenden, the chair of the Joint Committee on Reconstruction, when addressing a proposal to extend privileges and immunities of citizenship to all persons born in the United States, that was it, Fessenden stated that one may be born but not be a citizen. Senator Wade, the proponent of the language, rejected that notion, to which Fessenden responded, suppose a person is born here of parents from abroad temporarily in this country. That's not definitive, but it strongly suggests he thought such persons would not be covered. Here's some additional evidence. Two secretaries of state in the 1880s denied that a person born in the United States to temporary sojourners was a citizen. And the court in Wankemark specifically decided the question whether the children born of domiciled permanent residents were citizens. Quote, "The amendment in clear and manifest words includes the children born within the territory of the United States of all persons of whatever race or color domiciled within the United States. Every person or subject of another country while domiciled here is within the allegiance and the protection and consequently subject to the jurisdiction of the United States." Why would the Supreme Court have mentioned this so many times if domicile was irrelevant? Now, perhaps Evan will respond that they just didn't know what they were talking about. But Trumbull, Wilson, Fessenden, Bingham, that's a lot of people in the know with respect to the Civil Rights Act and the 14th Amendment. But maybe they were wrong. Maybe the Secretaries of State were wrong. Maybe Wong Kim Ark was wrong to focus on domicile. That's a lot of people who were wrong under the traditional theory. And I haven't mentioned the other treatises and secondary sources. An international law theory of jurisdiction can at least explain this evidence. That's because under international law, it was held that the nation of domicile maintained a legislative jurisdiction over personal status rights such as marriage, capacity to contract, and citizenship over its foreigners abroad. Under international law, a sovereign could also decline to exercise a judicial jurisdiction between transient foreigners. And it appears that domiciled foreigners, but not transient visitors, were subject to militia service of the local sovereign in which they were domiciled under prevailing rules of international law. In these various ways, the jurisdiction exercised by the United States over temporary sojourners was less complete than the jurisdiction it exercised over its own citizens or over domiciled permanent residents, to use the language of Jacob Howard. Let me offer one final example that the international law framework can explain that the territorial or sovereignty-based view cannot. Justice Joseph Story wrote an opinion, the reasoning of which was adopted in a later case by the full Supreme Court, that suggested he would have held that children born in British-occupied territory to loyal American parents would be deemed natural-born American citizens upon reconquest. Perhaps this was a one-off quirky exception, but Story's opinion was well known in antebellum America since the case in which it appeared was the Supreme Court's most comprehensive treatment on the subject of birthright citizenship. And Joseph Story was also Joseph Story, right? None of the prevailing theories, territorial jurisdiction, criminal jurisdiction, a sovereignty theory, can explain this issue of persons born in occupied territory. But international law can. Under the law of nations, there was a rule called post limine, which is a rule of the Roman law, which provided that the personal rights and conditions of captured persons continued to be governed by the original sovereign and would be restored to their original condition upon a reconquest, as if they had never been changed. In a sense, this actually parallels the domicile example. Citizens in occupied territory are merely sojourning, so to speak, in the territory of the other sovereign during temporary occupation. Under international law, the jurisdiction of the original sovereign continued in force over their personal rights and conditions and their citizenship, even if that sovereign's other laws were held to be temporarily in abeyance. Okay, in this opening salvo, I have not said anything about the rule with respect to unlawfully present aliens. Was there an international law rule with respect to them? I propose that there might have been, and I hope to have more time to talk about it, but I'm at my agreed upon 12 minutes.
All right. Well, let me give Evan a chance to respond to that, and then we'll move forward and talk some about those who are potentially here illegally.
Sure. So very quickly, with reference to Wong Kim Ark, the Supreme Court has never held that Ilan Wurman has the right to say incorrect things about the 14th Amendment, but I think it's fair to say that it has resolved the question in favor of him having that right. I don't think that there is anything in Wong Kim Ark's reasoning that turns on a domicile requirement for the basic reason that the court says it's following the common law, and there was no domicile requirement at common law. I don't know how many of you are on Blue Sky. I don't anticipate many of you are, but I have gone through every single reference to domicile that Ilan just mentioned and explained why it does not support the proposition that he is seeking to establish here. I think the strongest piece of evidence is the letter from Trumbull to Andrew Johnson. I have a couple of things about that letter, however. First of all, Ilan, have you read the letter?
No, I'm relying on Mark Shahan.
Okay, so I suggest that you read the letter. Find a way to read it. It's hard to read. It's very, well, I don't want to criticize Lyman Trumbull's handwriting, but it's difficult to decipher what is going on here. But I'm going to assume that Mark Shahan is right about the way that he is characterizing it. This letter is a private letter from one senator to Andrew Johnson, that the substance of which was never repeated by its author and wasn't apparent to anybody until Mark Shahan brought it up in a law review article that he subsequently revisited and answered in favor of saying it is irrelevant to original public meaning because nobody ever saw it. It's a private letter. Who cares? Okay. So what's striking to me, though, and this is where I want to give Ilan a little bit of credit, is just how much we agree about on the basic question of what it means to be subject to U.S. jurisdiction. His description of the jurisdictional situation of tribal citizens in particular is excellent because he explains how they're not subject to U.S. municipal jurisdiction. Why not? Because they're not governed by U.S. law. Ilan says that they were generally or substantially governed by U.S. criminal law. That's not true. There was an 1817 criminal statute that related to crimes between Indians and not Indians, but there was no general criminal jurisdiction over them for a very long time. What Lyman Trumbull and Jacob Howard say over and over again about Indians is you can't sue them, you can't prosecute them, not on their territory, maybe some delimited exceptions. And this situation is just so fundamentally different from the situation of unlawful entrants who have no sovereign territory, who enjoy no such immunity from statute, that I think that the analogy is totally misplaced. It's an own goal. The very differences between tribal citizens in 1868 and unlawful entrants today are so substantial that I don't think you can recognize the tribal exception and the reasons for it without totally defeating any case you might make against unlawful entrants. Again, blue sky thread, domicile requirement, not a thing. And in fact, the court in Wong Kim Ark specifically cites the only antebellum case that adjudicated the status of children of temporary visitors, Lynch v. Clark, 1844, widely reported, far more than the couple of New York cases that Ilan later mentions, which, by the way, don't question Lynch v. Clark. He's referring to dicta in those cases. And you don't cite that case unless you know what it means. Anyway, other than that, I love the play.
Okay, I actually want to. I'm going to exercise the moderator's privilege for a moment and ask you a couple of follow-ups.
Sure.
Okay, so on the letter itself.
Yep.
Okay, I understand the argument to say, well, if it's private, it doesn't inform original public meaning. What about the notion that it reflects original public meaning? It is written by someone who's immersed in public debate at the time and could therefore be reflective of what that meaning was, even if it's not informing that meaning.
It could if other senators and representatives had said something like it, and they didn't. I've gone through every single one of these examples that Ilan mentioned, the Wolson example, the Fessenden example. Fessenden doesn't say anything. He raises a question about whether temporary visitors are, children of temporary visitors are included, and Benjamin Wade says the answer is obvious, they are. The Wilson reference is in the midst of the discussion of black citizenship, and he's not commenting in any considered way on anything. And I think it's best understood as a reference to diplomats who, by the way, are temporarily present. There's just nothing there. Anyway.
Okay.
Second one.
Go ahead. No, oops. Go ahead.
Sorry. No, you're actually doing well, Judge. Sorry about the water. So I think it's important to recognize that these are all pieces of evidence that suggest people thought this. People who would have known something about the common law. Yeah, Fessenden raised a suggestion because the point wasn't obvious. Wilson said it. Yeah, okay, well, I still haven't understood exactly why what Wilson said isn't probative in this regard. Lyman Trumbull thought it.
I'll give it to you.
Fessenden thought it. Well, yeah. And these are all the people they're drafting. So all these people had this doubt, right? That is evidence. What evidence does Evan have that anybody said, oh yeah, temporary sojourners were included? Benjamin Wade, right, Senator Wade, in that discussion suggested, I'm not sure what you're talking about, but it must be a small number of people and we shouldn't make an exception. He has the common law of Lynch v. Clark. Did you know in Lynch v. Clark that Julia Lynch's lawyer, the alien who was born, or the child who was born to a temporary sojourner who was at issue, her lawyers said, Judge Sanford, her dad was domiciled. Her dad was domiciled. And the judge said, well, I'm not sure he was domiciled, but in any event, I think she's a birthright citizen. Why did her lawyers think? I mean, they were being good lawyers. Here's the New York court that I'm apparently not supposed to talk about. in 1860, a 2-to-1 decision, by the common law, now this is referring to a child born to American temporary sojourners abroad. By the common law, when a subject is traveling or sojourning abroad, either on the public business or on lawful occasion of his own, with the express or implied license and sanction of the sovereign, and with the intention of returning, that subject continues under protection of that sovereign power. So he retains the privileges and continues under the obligations of that allegiance, and his children, though born in a foreign country, are not born under foreign allegiance and are an exception to the rule which makes the place of birth the test of citizenship. Okay? So to say that somehow this was a common law rule is wrong. Judge Sanford had an opinion about it, and which itself demonstrates that this was a debated and open question at the time.
Just very quickly, it was not debated. Ludlam v. Ludlam was not understood by anybody as undermining Lynch v. Clark. Ludlam v. Ludlam, sorry, it is difficult to say, is a case about the children of American parents born abroad. And in that context, of course, you have to depend upon the statutory guarantee that the children of American parents, of citizens, is dispositive rather than birth in another jurisdiction. But Lynch v. Clark is one of the most widely reported cases. It's cited in congressional debates about the Civil Rights Act. Time and again, commentators in the late 19th century even cite Lynch v. Clark to explain why international lawyers who say that there is a domicile requirement in the 1880s are obviously wrong because they're ignoring Lynch v. Clark. This is a very important case. I don't think that Ilan can get around it. And like, even if he could, we're relying upon what? A questionable inference from one senator in the course of a speech about something else, when Lyman Trumbull, whose letter we are supposed to be crediting, specifically says in reference to the question of whether the children of Chinese nationals born in the United States are citizens, knowing, as everybody knew, that many Chinese nationals went back and forth and didn't stay in the United States, unambiguously says, yes, yes. I don't think that there's any there. There are too many authorities from too many periods of time saying Lynch is the law. There is no exception for temporary sojourners. And also, when are we going to talk about unlawful entrance? I'd like to talk about that.
I'm about to move us there, right?
Yeah.
Because I do want to get there before our time expires.
Blue
so obviously, the reason that this is a topical debate now is because of the discussion about illegal entrance in the country. Let me maybe hear from Ilan first. You're talking about this from the context of domicile, a domiciled residence. Why does that then extend? The president issued an executive order on his first day in office that seems to go beyond just sojourners to people who are potentially domiciled here. They're just not here, with the approval of the government through appropriate channels. Why does the 14th Amendment birthright citizenship provision, why are they not subject to the jurisdiction of the United States?
Okay, so what is the thank you. So I go first in this round.
Right.
So what is the connection to domicile here? Actually, none. And the reason domicile is relevant is if you think that the data that I presented is evidence that has to be contended for and suggests that there was this view that non-domiciled visitors were not subject to the jurisdiction, an international law theory explains that. No other theory can. That's the point of mentioning domicile. And of course, it would suggest that at least part of the president's EO is constitutional. Whether, so what does that leave, where does that leave unlawful entrance? Well, I guess it depends on whether there is an international law rule that might apply to that situation too, such that we can come to a similar conclusion, okay? So the question becomes why? Were there exceptions under international law to begin with to the exercise of municipal jurisdiction? And do those reasons apply here? Let me just reiterate that one could agree with the international law framework and agree with the domicile, but disagree with my application here, or vice versa, Okay. So here's the argument. I suggest that there is an international law rule that the municipal jurisdiction of a nation applied if an alien was under the protection and within the allegiance of the sovereign. Otherwise, the law of nations would apply. Allegiance and protection were also determinative of the birthright citizenship rule at common law. So in this sense, birthright citizenship and jurisdiction are intimately connected. So let's start with the common law rule. The common law rule was that an infant born in the realm received a protection from the king in infancy, which created in turn a debt of perpetual allegiance. But what if a child was born to a member of an invading army? One of the exceptions. Sir Edward Coke explained in Calvin's case that such a child would not be a natural-born subject because not born under the protection and within the allegiance of the king, even though within the king's soil. Now, what about a child born to friendly aliens, aliens from friendly nations? They were natural-born subjects, Coke wrote, because their parents were, temporarily, subjects of the king. An alien friend receives a local protection while in the realm, and therefore owes a local obedience or allegiance to the king while in the realm. This exchange of allegiance and protection is what made an alien parent a subject, and therefore the child born a natural-born subject. Such a child is born, quote, under the ligiance or connection of a subject that is born to one who is temporarily a subject of the king. In other words, at common law, the deciding factor was whether the parents of a child born were at the time under the protection and within the allegiance of the sovereign. Now, I want to suggest that this exchange of allegiance and protection was a social compact between the alien and the sovereign. After all, the alien parents had not received any protection from the king in infancy. The allegiance they owed was entirely due to the result of the exchange between them and the sovereign of protection for allegiance. At common law, then, one might doubt whether alien parents who come illegally, contrary to the king's wishes, would have been considered subjects of the king. Can one be a subject of the king in the sense Coke used the term by unilaterally entering the realm in violation of the king's wishes? Has such an alien parent entered into this exchange of allegiance and protection? It's at least open to doubt. Now, perhaps that has nothing to do with jurisdiction, but it turns out it does. It turns out that whether an alien was subject to the municipal law depended on whether he was under the nation's protection and within its allegiance. Here's Chancellor Kent. During the residence of aliens among us, they owe a local allegiance and are amenable to the ordinary tribunals of the country. With allegiance and protection comes an ordinary municipal jurisdiction. Here's Chief Justice Marshall. It would be obviously inconvenient and dangerous if visiting individuals or merchants did not owe temporary and local allegiance and were not amenable to the jurisdiction of the country. So again, one follows the other. Here's the court in Wurman. Every citizen or subject of another country while domiciled here is within the allegiance and the protection and consequently subject to the jurisdiction of the United States. Consider a few more examples. During the War of 1812, the courts had to address the matter of British subjects in America who were not engaged in hostilities. They were friendly, but they were technically enemy aliens under the law of war. So they could be permitted to stay and to have the benefit of the municipal laws. Here's what Chancellor Kent said in a case about this. Quote, "The law grants permission to the alien to remain, though his sovereign be at war with us. A lawful residence implies protection and a capacity to sue and be sued." In the case of Charles Lockington, who was in violation of a presidential order of exclusion, the Chief Justice of the Pennsylvania Supreme Court stated, analogizing his condition to that of a prisoner of war, quote, "He has no municipal rights to expect from us. We gave him no invitation and promised him no protection." Now, does this apply to aliens generally, as opposed to just enemy aliens, this category under the laws of war? No one can say for sure because the question was never addressed before 1868. But why would the answer be any different? It's certainly not obvious. Perhaps under the law of nations, a local sovereign can't subject unlawful entrance to martial law, to the laws of war, but it was nevertheless a violation of the law of nations to enter another sovereign's territory illegally. That's what both Vattel and Blackstone suggest. And again, under the law of nations, municipal jurisdiction followed from an exchange of allegiance and protection. Does the sovereign owe unlawful entrance protection? Must a sovereign allow unlawful entrance to its nation, access to its courts, and make them amenable to its ordinary jurisdiction? In these senses, they would not, by default under the 14th Amendment, have to be treated as subject to the complete legislative and judicial jurisdiction of the United States. Let me end this point with a quotation from Wong Kim Ark majority. Wonkamark's parents, the majority held, are entitled to the protection of and owe allegiance to the United States so long as they are permitted by the United States to reside here and are subject to the jurisdiction thereof. It seems to me that if Wonkamark is all we have to go on, then it supports this conclusion. Jurisdiction follows from allegiance and that protection derives from a lawful residence. So what's the bottom line for President Trump's executive order, which it should be noted applies prospectively? Let me suggest that the answer is that the lower court injunctions should be vacated and claims to citizenship should be adjudicated on a case-by-case basis. Perhaps there is one rule applicable to temporary sojourners who owed a temporary allegiance to the sovereign, but over whom the United States did not necessarily exercise a complete jurisdiction under international law. By the way, I didn't get into it here, but there is a third view on offer, which is any child born to temporary sojourners might be able to come back to the United States around the time of reaching the age of majority and elect U.S. citizenship. That certainly could not be resolved in a pre-enforcement universal injunction posture. And perhaps there's still another rule for unlawful entrants who arguably never entered into an exchange of allegiance and protection. Perhaps the rule is different if the alien is excludable versus removable, second generation versus first generation, if Congress or the president, for example in DACA, has in fact, in practice, treated them as subject to the jurisdiction or not. Bottom line is, it seems to me that universal injunctions against the order are unjustified, whatever the ultimate merits of particular cases might be.
All right, thanks, Ilan. So, Evan, this is a somewhat challenging argument for you because it rests on the predicate that you were wrong on the scope of the jurisdiction clause in the first instance.
Yeah,
right?
I can't accept that. Okay.
Yeah, I'm instructing you have to. It's like when I pick
sure.
Wardier and I tell people they just got to listen to what I say. All right, so, starting with that premise, what's your response if we're in a world where either international law applies, provides some guidance to us, or otherwise? Why would the exceptions not include those who are here illegally?
Because Ilan has made no substantial showing that either in 1788, 1868, 1888, whatever date he wants to pick, that anyone understood unlawful entrance to be some subcategory of aliens whose children could not be citizens. He initially made a claim in a co-written op-ed that, with Randy Barnett that aliens who crossed borders illegally were, as a consequence, alien enemies, not in amity with the United States. If that were true, that would have consequences for the citizenship of their children. The problem is that, as I think Ben Keener has shown in an article that was published fairly recently, the claim is false. There was no subcategory of aliens between alien friends and alien enemies that included unlawful entrance. You were either an alien friend, in which case your children got citizenship if you were born in the United States, or you were an alien enemy, in which case you were invading, crossing the border to take over the country. Now, not even Ilan is contending that that's how to think of your average unlawful entrant. So the problem is that I think he has to accept, unless he is going to stick to this amity claim, which is no longer in his draft, that unlawful entrants are alien friends. And alien friends, children, get citizenship if we're committed to birthright citizenship. And I'm just going to make a final observation. I am not an international lawyer. Ilan is not an international lawyer. And I don't see why the meaning of the 14th Amendment should turn on either Ilan or my understanding of international law, particularly since I don't know which international law we're talking about. Again, what dates? 1868, 1888, 2025. It raises a bunch of questions that only need to be asked because of a very complicated theory that refuses to take their citizens, it's obvious, for an answer. And I think it is obvious if you look into the relevant common law history that the framers were trying to incorporate.
So let me ask you a couple questions, Ilan, because I think
Oral argument.
they flow from something. I made a couple notes, and they flow from something that Evan just said. So as you talk about international law, right, and we're talking about this, I think you've been talking about this, at least claiming, and I'm not disparaging or promoting, but an originalist prism to what you're doing. So is international law, in your view, fixed as of the time of ratification of the 14th Amendment? Can it evolve? Are we now looking at whatever the UN says is the scope of international law for how you treat migrants? I mean, what's your view on where we're looking for this?
Yeah, so on that, there's another methodological question here, which I think Evan raised, which is, well, they didn't say anything about this in 1868. That's what I heard him say. I don't think he means it. The question is the meaning of what they wrote and whether you can operationalize that to future circumstances they might have been unaware of. I think Evan would agree that generally originalism cares less about the expected application at the time based on whatever problems they were confronting and cares more about the meaning of the words they wrote, which is what I'm getting at.
Yeah.
And if the meaning of what they wrote was that subject to the jurisdiction depends on whether under international law they are subject to the jurisdiction, yes, that can change depending on whether the rules of international law change. Just like whether an alien is an unlawful, say, present alien, whether that person is subject to the jurisdiction of the United States might change when Congress's laws change. Congress might decide there's no more category of excludable aliens. Anybody who comes here is treated just like they're intending to be domiciled. Congress could do that. The question is, what is the default rule under the 14th Amendment? And by the way, Congress might have done that. I actually haven't really talked about various immigration laws in this context. But if the default rule is subject to the jurisdiction, pegs this to international law, whether there's an international law, whether the law of nations applies or there's an international law exception to the exercise of jurisdiction, yes, that could change over time. We could regress, I suppose, to a time where we do kill ambassadors, kill the messengers, or something like that, I suppose. And then I do think the application of the amendment would change. I don't think it's fixed to its particular applications in 1868.
I just want Ilan to be very, very sure about something like that before he says it. Because if that's true, that who can be entitled to citizenship in the United States turns on the state of international law, we just have a whole host of implementational questions that frankly boggle the minds in terms of how we identify the relevant norms and apply them. So I'm not asking for somebody literally saying, yes, we want to peg our understanding of who is a citizen or not to international law. But I need more than it might be or maybe to have confidence in a claim like that, because there's no other constitutional provision that I can think of for which what he is saying is the right way to think about things. He cites
the privileges or immunities of citizenship
sorry, the privileges or immunities
evolve
of
over time. Didn't you say that in your book with Randy?
I did. If 2/3 of states agree that a
2/3 of nations.
2/3 of nations. Well, at least
international law.
no, at least these nations are not separate nations. They're states within the United States. They are norms that develop in this country rather than somewhere else. Just really quickly, you cite Robert Nadelson, who takes who says that there is a law of nations norm against unlawful entry. But what he doesn't say is that a law of nations norm, in virtue of being a law of nations norm, changes the meaning of the U.S. Constitution. He says that there's a define and punish offenses against the law of nations clause, and Congress can exercise that power and make it part of our positive law. What you seem to be saying is that it automatically happens. There's no positive act that Congress needs to take in order to make the law of nations into U.S. constitutional law. And it could be the case. It's just I would need to see a lot, and maybe and might be is just not enough for me.
Let me. I want to ask Evan a question. I also want to know. I mean, I don't remember exactly when we're supposed to wrap up. We started a little late. Okay, but I do want to give people a chance for. Yeah. Well, no, I'm not worried about the bar so much, although I am. But I want to make sure that people have some chances to ask questions if they want to. There are the two microphones. If you have them start lining up, I'm going to ask Evan a question, and then I may start taking some questions from the audience as well. Mm-hmm. But so Evan, I guess one question I have is, you when I asked you to rebut Ilan's point on this issue of those who travel internationally, I think where you started was Ilan has not cited us evidence from, whether it is 1789 or 1868 or 1888, et cetera, to say that, well, this was the understanding. And I guess I want to flip that on its head for a moment and just ask, is there evidence to the contrary that would suggest that the understanding was that, in fact, those who came here illegally might, within the scope of international law, be considered, to be within the jurisdiction of the United States? Or is it just really that we are in sort of an area that was not discussed and is something of a blank slate?
So there were no norms against unlawful entry that anybody could cite in the United States because there was no general prohibition against unlawful entry in the United States. The closest analogous thing that you can think of is the prohibition against importing enslaved people illegally. But that's not quite unlawful entry because the people who are being forcibly imported obviously don't have a choice about it. Right. So you have to ask the question, like, given this allegiance protection frame, like, what do you do with this new case? And I think that the concerns that drove the allegiance for protection frame were, as I've suggested, concerns about domination. If you're governed by a state, you should have some means of recourse for asserting your rights against that state. And for that, you need citizenship. And that's what drove the idea behind an inclusive understanding of citizenship that carved out only groups of people who just weren't governed by the relevant states. So even if I'm prepared to accept, and I am prepared to accept, that you could add to the list of exceptions to subject to the jurisdiction, this one just doesn't look like any of the ones that existed. You have governance without protection. That's a problem. It's a problem that in the case of enslaved people, and I'm not comparing the cases, but I am saying that they are similarly situated in this respect. Enslaved people were governed, and they didn't have any citizenship, and that was the problem. Now you've got a class of people who are governed, and they don't have any citizenship, and that's a problem given that all the exceptions are about people who can't be governed. So even if the set is open, I just don't think this is the square peg, round hole, or round hole, square peg, I can never remember situation.
Okay. All right. So I want to open it up for questions. I want to remind folks, I know this is an issue that can inflame some passions. The microphones are not for speeches. They are for questions. So please ask a question. Don't make a speech. We're going to go back and forth, start over here, and then we'll go back and forth.
Hi, guys. I'm Ben Wallace. I'm in AUSA in Wilmington, Delaware. I want to ask about two pieces of evidence and just your view on whether they matter, and if so, how. So my at least recollection is that the text of the preceding Civil Rights Act contains a different text about who is automatically a citizen. Does that text matter, and if so, how? And then we talked about this a little bit, on sort of a general level with expected applications and a specific level with whether there was such a thing as an unlawfully present alien. Does Professor Newman's work about people who are unlawfully present in their states at the time of the ratification of the amendment matter, and if so, how?
So I will, address the first question first. So I think that the
And to the extent you have it, I don't need exact verbiage, but Ben referenced it, but maybe tell us generally what
so
the Civil Rights Act
there are
said.
two competing schools of thought, genuinely competing schools of thought on the significance of the Civil Rights Act of 1860. One is that the language not subject to any foreign power, has an identical scope to subject to the jurisdiction thereof, with the exception that there's a part about Indians that gets moved around, and there's more inclusive language to deal with the suggestion that perhaps Indians will be citizens. And the other is that, subject to the jurisdiction thereof seems to be broader than subject to no foreign power, narrower than subject to no foreign power in respect of its exclusions. I am not actually committed to a position on that. What I will say is that even if we say not subject to any foreign power, should inform the meaning of subject to the jurisdiction thereof, you look at those debates and you will see the same kind of thing happening. Subject to no foreign power does not mean you're a foreign national. Not even Ilan is going to take the position that Wong Kim Ark is not a birthright citizen because his parents were Chinese nationals. So I think we have the same debates, and I think it should be resolved in the same way, regardless of whether we say subject to no foreign power is identical to subject to the jurisdiction thereof in its coverage, or if we say subject to the jurisdiction thereof means something slightly different.
I've not forgotten the second question, but can I say something about this?
Yeah, say something about the first one, and then we'll go ahead.
So both Lyman Trumbull and Jacob Howard said the operation of the 14th Amendment was identical to the operation of the Civil Rights Act, right? All persons born in the United States and not subject to any foreign power. The difference in language was intended, as Evan said, to clarify the status of so-called Indians not taxed. And does that mean there's a property requirement or what have you? It's interesting because it is easier to conceive of temporary sojourners as remaining subject to a foreign power. In a way, I think that domiciled foreigners are not subject, remain subject to a foreign power. Typically, especially, there's further steps to the naturalization process and so on, but certainly domicile is part of that, which explains why in those debates, James Wolson said, oh, temporary sojourners, not covered. Now, maybe he didn't know what he was talking about. Maybe he was being flippant. It would explain why Lyman Trumbull wrote the letter. That language would explain that, not subject to any foreign power. Wong Kim Ark was a hard case. Why? Because Wong Kim Ark's parents were domiciled permanent residents who would have become citizens if they could. Well, there was naturalization law problems as well there. But there was a treaty with the Emperor of China specifying that his subjects in the United States would remain his subjects forever. And in that sense, the emperor was trying to get out of this subject to any foreign power, make sure they're always subject to that power. That's why it was a hard case, because you have this treaty that seems to derogate from the default rule that if you're domiciled alien, you count. That's why it was a hard case. I think it was rightly decided, but it was hard for that reason.
Remind us a second.
It was about there weren't people who were unlawfully present in the country.
Oh, in the States. They were unlawfully present in the States.
Yeah, and to the extent that's relevant, it actually helps the case for inclusive birthright citizenship, because there was an entire birthright freedom movement that was established by abolitionists with the eye to ensuring that even if you cross state borders illegally and could be removed and returned to enslaving states, your children could still be citizens. And that informed how Republicans thought about things. Now, you can say, well, technically they weren't unlawful entrants. Well, true, but the general principle is that crossing a border shouldn't affect the citizenship of your child, and if unlawful entrants get excluded, that's contrary to that principle.
So on the freedom suits, which I think is interesting, and Amanda Frost has written important work on this, to be clear, like the state of Pennsylvania would have had to give up the parents, right, and the child possibly, okay, which they had laws against. Anyway, under the Fugitive Slave Clause, they would have had to return such fugitive slaves, okay? But Pennsylvania declared any children born, to fugitive slaves or previously enslaved. It wasn't directed at fugitive slaves. It was enslaved people generally, okay, were citizens. And so the question is, does the fact that they had to send them back mean they had some unlawful status? Not under the laws of Pennsylvania. Yeah, maybe it was illegal for them under the laws of South Carolina to escape South Carolina. And maybe Pennsylvania had to return them, or to Maryland, more like it, okay, under the Fugitive Slave Clause. But they weren't illegal entrants to Pennsylvania. They were under the protection and allegiance of Pennsylvania.
Let's go over here.
Thank you to the panelists. Thank you to Judge Wolson for moderating. Ilya Podolyago from New York. I have a sort of compactish question because these terms come up in another case that's vaguely related, not exactly on all fours, New York versus New Jersey. You mentioned sovereignty and jurisdiction, and I was hoping the both of you could define each one and distinguish them, because that has confused me as I read through New York versus New Jersey in its various iterations at the Supreme Court. Thank you.
So you're not going to get a neat distillation of the difference from me, but I will tell you that very roughly, jurisdiction just means you are daily, ongoing basis subject to sovereign power through all three branches of the government. And the reason why I can't say they're just identical is because you can refer to, for example, tribal citizens being under the jurisdiction of the United States through the General Crimes Act of 1817 without suggesting, subject to the sovereignty of the United States without saying that you're subject to the jurisdiction thereof. So I think that these are, commonsensical ways of thinking about governance power. If you're subject to sovereign power on an ongoing basis, you are subject to jurisdiction for the purposes of the 14th Amendment. And I do look at jurisdiction through sovereignty and not with reference to international laws, understanding thereof.
I think the word jurisdiction is used in different ways in the Constitution itself, if you even want to do intertextualism. And so the way they seem to be using it is in the international law sense. What do I mean by that? Under international law, there's a question whether you had a legislative jurisdiction. What did that mean? Whether you can make laws with respect to certain people and certain rights. This is what explains why the native tribes were within the United States territorial jurisdiction, subject to their criminal jurisdiction, to their foreign policy jurisdiction, but not to their complete legislative jurisdiction in that sense. And so it at a minimum, I think, means that. But what they meant by it in that particular term, you have to collect it from the data, and it seems to be that international law term.
Let's go over here.
Gentlemen, thank you, first of all, for the amicable debate, or not so amicable, depending how you want to phrase that. I wanted to ask, have either of you considered or thought about the fact that the Enrollment Act of 1863, which was the draft act, only drafted U.S. citizens or those seeking citizenship. It excluded those who were still enslaved at that time, and would obviously have informed those people who were looking at the jurisdictional element, because as a JAG officer, Charles Bennett, doing this on my own behalf, not that of the DOD, et cetera, all the caveats. What I'm asking is, that one key for allegiance seems to play a role in understanding jurisdiction, and it certainly did in 1863 and would have in 1868 or any other date.
So Ilan has developed an argument about the significance of conscription. I will say that my understanding of subject to the jurisdiction thereof does not mean that the United States exercises the exact same quantum of power over every class of people in the United States. So the fact that some people might be subject to conscription and other people not does not make them not subject to the jurisdiction if they can't be conscripted, because then you have the really weird consequences like, well, if women can't be conscripted, then they can't be citizens in the United States. That's a little bit complicated. Ilan has an explanation for why that might not be a problem, because there might be an international law norm against conscripting non-domiciled foreigners, but not against conscripting women. I think that is attenuated and complicated in ways that demand expertise that neither of us has about international law.
Can I just say that I think Evan is right to make that concession, that his view requires the understanding that being subject to the jurisdiction does not mean that the United States must exercise the same quantum of power as it does over citizens, for example. But just note again, that's exactly the opposite of what Jacob Howard said. And maybe Jacob Howard didn't think about this, but again, he said a full and complete jurisdiction, coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, the executive judicial department, that is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States now. So if, for example, there was a rule that said domiciled aliens, but not just people who happen to be caught up on a transit, could be conscripted, for example, into the militia. There was an Alabama case during the Civil War that said that, actually, that domiciled aliens were subject to conscription. Then that's another international law explanation. It's almost like when you state it, does international law provide for some rules with respect to how a sovereign treats foreigners from other nations transiently in their territory? Like, of course it would have some rules, and it did. And if that's the test, or if my test is correct, or if Howard is correct, then doesn't that answer it in some way?
No, Howard doesn't say anything about international law in that passage, Ilan. You can't say that he is literally saying that the amount of U.S. power over every single person in the United States who is born there is identical. If that were true, then you'd have consequences like even green card holders' children are not subject to the jurisdiction of the United States because the U.S. doesn't exercise the same amount of power over them as it does to native-born citizens.
So can I say something? This is productive, because Lyman Trumbull does say something, I think, about international law. Lyman Trumbull is asked repeatedly, he's like, what are you talking about? They're not subject to the jurisdiction, the native tribes. Of course they are. We have military overseers. We subject them to our criminal laws. They're within our territory. And Trumbull basically said, well, we enter into treaties with them basically because they're their own dependent nations. So we may exercise some degree of that power over them, but it wouldn't be in a legitimate sense, he says, a legitimate sense. In what sense would it be illegitimate if not under prevailing rules of international law?
Alana, are you really saying that the United States
I
cannot...
can't understand what you're saying, sorry.
Alana, are you really saying that the United States cannot subject unlawful entrance to its criminal laws?
I don't think that's the test.
Okay, so then
The
what
native
about
tribes,
transient...
the native tribes were subject to the criminal laws.
That's
in
not
in the
what-
General Crimes Act of 1817.
I suggest that people read the primary sources that he is citing, because if you literally look at what Lyman Trumbull is saying about whether you can sue or prosecute Navajo Indians, he's speaking categorically and saying, no, you can't. And if Ilan is really committed to the proposition that we need to treat unlawful entrants like tribal citizens circa 1868, I don't see where we get the authority to say that unlawful entrants are subject to our criminal laws.
They're the fireworks you were promised.
Yes. All right, we have two more questions. I want to get to them. So right over here, you've been waiting patiently. Go ahead.
Okay, Paul Johnson from New Jersey again. One thing, Professor Wolson, Congress did act on the Citizenship Clause a century ago when it passed the Indian Citizenship Act of 1924, so they did make adjustments to that. And Professor Bernick, welcome to the Lion's Den. I just had a question. I'm not quite sure I know the answer to the question, so I'll ask. As we know, the Citizenship Clause really was directed at blacks, means not just slaves, but all blacks, overturned Dred Scott. So the clause we're talking about, this jurisdiction clause, obviously wanted to exclude somebody, at least some classes of people. What if they forgot to put it in, or they just didn't think to do so? It would have been ratified. Would we have conferred citizenship to American Indians, the combatants who are here occupying, or what's the third category?
Diplomats.
Diplomats. I would think it would have been unthinkable to grant citizenship to those people, even without that subclause. And if they wouldn't have done that, then they were talking about other peoples that we want to exclude, namely foreigners or aliens.
Okay.
So I'll start with the Indian Citizenship Act of 1924. This could go both ways. You could interpret it in various ways. One way, quite sympathetic to my argument, the Major Crimes Act was enacted in 1885, and I think under Evan's view means that at that time, now you might think that was illegitimate and beyond the Indian Commerce Clause or Commerce Power, what have you, but
I do, yeah.
right.
All
But
of
they
the
did it, and under Evan's view, that law should have subjected them, at least I think, to the jurisdiction in the sense of fully subjected, not even fully, to the criminal jurisdiction of the United States with respect to major crimes, and yet they still thought apparently that they needed to grant them citizenship in 1924 through naturalization law, which would make sense because under my view, subjecting them to jurisdiction in a limited respect is not subjecting them to the complete municipal jurisdiction of the United States. On the other hand, maybe they were at that point subject to the complete jurisdiction and it was just clarifying or to capture people born before the Major Crimes Act or before the Indian Appropriations Act of 1871. It's hard to tell exactly the significance of it.
All right, let me give you a chance on this notion that maybe this subclause was surplusage if it's interpreted the way you're positing.
So I don't think it's surplusage because I am saying that there are limitations that are incorporated by that language of subject to the jurisdiction thereof. They're just not particularly significant broad exceptions that are available. At a minimum, it's not that you need to have a closed set, but the set that or the things that you add to the set have to look like the existing things in the set. You can't, it's not surplusage, but, the 14th Amendment framers did not hide elephants in mouse holes either. Subject to the jurisdiction was not a limitation that gave you a license to just say, oh, Japanese people, their children can't be citizens because we can limit the categories of people who are subject to the jurisdiction of the United States. You have to show that the exception was either rooted in what people understood the exceptions to be or that it looked like them. And I don't think Ilan has identified exactly why unlawful entrants or temporary visitors are like the exceptions that have been identified. Really quickly on the Major Crimes Act and Indian citizenship more generally. So I think this is a real problem for Ilan. In 1870, the Senate Judiciary Committee makes a statement to the effect that regardless of what Andrew Jackson did, and regardless of what the Supreme Court did in a couple of cases in the 1840s, Worcester v. Georgia is the law of the land. we do not exercise municipal jurisdiction over Native nations, and we don't have the ability to impose citizenship on them without their consent. Now, flash forward a decade and a half later, Congress is allotting native land, opening it up for settlement, has banned treaties with tribes, and is exercising, yes, general criminal jurisdiction, although limited to major crimes over American Indians. Now, I have a very straightforward response to the claim that this did anything to alter the meaning of this subject to the jurisdiction thereof. All of that shit is unconstitutional. And as a consequence, I don't need an explanation for how the citizenship for why this all needs to be somehow constitutional or consistent with the original meaning of the 14th Amendment. I think it's inconsistent with it. But I think that it's a problem for Ilan if what he is claiming is that Congress has the ability to make American Indians who are not subject to the jurisdiction thereof in 1868 citizens, but Congress, what's your view about the
Well, hold
birthright?
on. No, we're not going to, we need to wrap up. So we
Okay, well, very
there's more
quickly.
new questions.
Congress has guaranteed citizenship to the children of unlawful entrants. It's done it in a bunch of statutes that Ilan doesn't even discuss. If for some reason they were originally excluded from subject to the jurisdiction thereof, surely they should be able to do it for unlawful entrants children as well as for American Indians children.
Okay, we have one last person who's been waiting patiently. We're running close to time, but I'm going to honor the fact that you've been standing there. So please, last question of the day.
Yes, hello, I'm Christine J. I'm a 3L at Temple Law. I'm also writing about birthright citizenship. And I think—
Be brave.
a major issue I see in Wong Kim Ark is about permanent domicile and what it means. So I was hoping that both of you could answer what you think permanent domicile means and actually how our Supreme Court will analyze it today.
So that's one thing in the paper that I don't do. Like, so obviously I spoke about the role I think domicile has in my theory, but I don't really talk about what domicile is and how you determine it and its subjective intent. Fair enough. That just proves my point that this should not be a universal injunction in a pre-enforcement stage. And you know, if every claim to birthright citizenship requires a hearing, like that, you know, if that's what, that doesn't bother me for the simple reason that it requires a hearing or the simple—
Bothers me unless I get a raise. Just to be clear.
Yeah. Well, we could a bunch of Article 1 courts, you know. Like, well, anyway, so that doesn't particularly bother me. That practical, functional.
Evan.
Yeah.
Just quickly, it really should bother you because you can't possibly defend the constitutionality of a categorical solution to something that you said as a constitutional matter is a case-by-case problem to be adjudicated on the basis of subjective intent of individual would-be domiciliaries or maybe not. Like, you need a theory of what domicile is in order to adjudicate any of these cases. Unless and until you offer that theory, I don't see how you can defend any part of the executive order.
All right, this was a great debate. I hope everyone enjoyed it. We are wrapping up, but before we do, I want everybody to stay put. We're going to ask Emily to come on up and—
Well, thank you,
yeah,
guys.
thank you very much, everybody.